Hello and welcome to the Silver Shemmings Ash Construction Law Podcast. I'm Sean Lothorpe, a business journalist, and I'm joined by two of the firm's construction lawyers, partner Henry Hathaway and associate Laughlan Steer. Thanks both of you for joining us. In this episode, we're going to help you decipher some of the finer points of construction law around repudiation and termination. Right, I think we're going to have to start at the beginning with this one. So, Laughlan, just tell us, what do we mean by repudiation and termination?
Well, Sean, in summary, repudiation is the right of an innocent party to terminate a contract because of a fundamental breach by the other party, and termination is the process of bringing a contract to an end, which follows thereafter.
So it's all gone wrong, in other words?
Indeed, yes.
Henry, what are the consequences of this?
Sean, invariably the consequences will be a financial one for one or the other parties. There can be a repudiation by the employer, can be a repudiation by the contractor. Ultimately, then, if the contractor is in repudiation leading to a termination, the employer has the right to employ others to complete the contract works and claim damages against the contractor. And that leaves the contractor in a very much loss of control position to remedy that. On the other hand, if the employer unlawfully terminates a contract, it could entitle the contractor to claim loss of profits for the remainder of the project to which he was denied the benefit of.
Is this a common occurrence in these kind of situations?
It can be very common. I mean, we actually deal with quite a few of these events, and it's our job to piece together the correct story and get our client's position as firmly and as robustly as possible, so that if and when they make a claim, everything's there in order. I suppose what we might do is take a look at some of the events that might constitute repudiation. And the key ones really to think about there are access. Do you have access to your works? Are you being prohibited from carrying out your works? Failure to remedy any works where they're defective works, that's another one. And giving works packages to other people as well, that would be another.
I think that's the most common with the employer.
Yes.
They've got into, because it's important as well, Sean, to realise when two parties get into a contract, they've set out an agreement that a set amount of works will be undertaken for a set value. If an employer, during the course of that event, meets another contractor and the other alternative contractor says they can do a portion of those works cheaper, the employer takes that works away from the original contractor, gives it to the new contractor. That's a repudiation, and that can lead to certain problems. From the practical aspect, before we go into the process, the practical aspects of this is that most times that it actually comes across our desk, it's based on a relationship falling apart. Necessarily, that it's not about related. The parties are bound to undertake obligations under the contract. So it's important that when they actually bring a contract to an end, they could be doing it unlawfully, if not for the right reasons.
I mean, I think we sort of touched on it a little bit there, Laughlan, but I mean, are there suspicious behaviours that people really need to be looking out for then?
Certainly there are, Sean. I know we'd always say to be forewarned is to be forearmed. And really, just on a very general level, it's a question of the conduct of the parties. And to sort of boil all of this down, the key question really is one of the parties evidencing an intention not to be bound by the contract? And if that's the case, then you're likely to have either a repudiation that may be arising shortly or one that is existing at that time.
Is there a sort of trigger point for this when you start to think, oh yeah, we're going down the repudiation?
That's exactly the question to ask, Sean, because it's the trigger point when the party actually knows and sees that this is happening. There can be a number of different ways in relation to when a repudiation occurs. First of all, the party might accept that repudiation there and then that gives a right to actually bring the contract to an end. But if they're not careful, they might actually affirm the contract, which they're still entitled to damages in that respect, but they have affirmed the contract in that point. If they leave it too long, there is case law on this, that if they leave it too long, they might lose their rights to actually accept repudiation, and that can be quite detrimental in that instance.
What's the tipping point then between, as you say, sort of repudiation and inadvertently accepting something? How do you know that you've inadvertently accepted something?
I think it's the clearest indication is an express statement. So an email, for example, saying, we are abandoning the works now. people don't write like that, but if it gives the purpose and intent that they're going to commit a fundamental breach of that or the performance of that contract, that's the most likely indication this is occurring. The second is by their conduct, quite frankly, and a series of events, as Laughlan said, in relation to any of the minor breaches that amounts to an overall repudiation becomes quite important.
How important then is it, Laughlan, that you note all of this down? I mean, you document all this if you think that there's something going on.
Well, we would always say that you should keep good records at all times, but I think the other thing to bear in mind is that you can actually have an anticipatory repudiation.
What does that mean? Sorry.
Well, and by that I mean, there's a good example, actually. A couple of weeks ago I had a client that rang me up and said, well, my guys on site have just been told that the main contractor have said, we're going to terminate your contract next week. So I said, well, that's great news, because we can rely upon that statement and say, you clearly do not intend to be bound by the terms of this contract, and we can then bring the contract to an end on that basis, even though the breach hasn't actually occurred on that day.
So how important is it then that you keep your ear to the ground?
It's a really key point. Don't ignore any warning signs, and make sure that you respond in a timely fashion to any threats, such as threatening to terminate the contract.
And I think what's very important for anybody who manages teams in the construction is to know that how people talk, if you like. Something about the construction industry is that people are so willing sometimes to give empty threats, and that if you don't. For a great example, I think, Laughlan, we've dealt with quite a number of times, is if a party hasn't been paid.
Oh, it's a classic.
And ultimately then they will say, well, we haven't been paid, whether or not it's due or not, and we're going to vacate. We're going to take everybody off the site. When you pay us, we'll come back. And I think that's a very common one. That's a clear repudiation. The Construction Act clearly identifies that they have a right to suspend, and those provisions are the ones that should be attached. But if those threats are affected, it is a repudiation. The employer has the right to terminate on those, because they, in effect, Sean, are abandoning the works. And that is a complete breach.
So what you're really saying is be careful about simply just downing tools.
Quite right. And in fact, there's a sort of irony about this, because if you get your process wrong here, you can be the one in repudiatory breach yourself. So really, it's very important to make sure that you follow the correct process, as we've outlined, in terms of if there are contractual obligations that you need to adhere to, you've done that. Or if you're going down what we would call the common law approach, that's also been done properly as well.
You mentioned the importance of documenting, process and things that are happening. But let's say looking at the other side, that hasn't happened, and there's an element of uncertainty around what's going on here. I mean, is that something that you could actually use to your advantage, because it may be your word against the other parties?
That's entirely correct, Sean. What we would often do is, when there is a period of uncertainty, i.e. who left first, what were any other arrangements in place between the parties, we make sure that our clients' interests are protected by way of, as Henry quite rightly pointed out, an express message, an example of something in writing that confirms the position we need to be confirmed, i.e. that we were the ones accepting the repudiatory breach and terminating the contract, not the other way around and being caught out in that fashion.
And it's desperately important that if we do have this point that we're willing to accept a repudiation in this circumstance, that there are very set procedures under the contract.
Yeah.
If you fail to administer those provisions for termination that are clearly expressed, you might find yourself in hot water as well. So clearly, if you intend to go down this route, it is a procedural mechanism, and it is to be adhered to very, very carefully.
And is there a time limit on this? I mean, when you need to be time frame with which you need to be acting within?
It's like a lot of these aspects. The very moment that you recognise that there is a problem, it has happened, that's the time to act.
And is that the time to call you, or should you have done that before then?
We have often given advice to parties who find themselves in this position, and we guide them through the process, both procedurally and to reach the evidential points that they are necessary to protect their position.
I mean, there's going to be fallout from this, isn't there? If you're going to go down this road, I mean, how as a business can you prepare for that, Laughlan?
Well, if we're talking about, say, you're a contractor and you've accepted your client or the employer's breach, then in terms of having a claim for loss of profit, what you're going to need to do there is to look at cash flow, look at turnover, look at similar sorts of projects. And it's really not finger in the air stuff. It's not pie in the sky. You've got to be very careful that the position you're putting forward is an accurate and realistic one. I've dealt time and time again with, shall I say, optimistic views of loss of profit, and ultimately when that goes before either a judge or potentially an adjudicator, that you're going to be laughed out of the room. So the point is to provide a credible explanation for your losses rather than use it as an exercise to recoup monies that you may or may not have been entitled to or would have earned.
Just thinking about the processes, because we're talking about repudiation and termination. I mean, when does one kind of flow into the other? And I'm thinking about the termination process now and what that looks like.
Yeah, we're back to the same point that we have recognised that repudiation has occurred. We have a choice. We have a choice. Do we accept that repudiation now, which then invokes termination? Or have we affirmed the contract, which means that we're happy enough that the contract shall exist, but give rise to damages? And effectively then, you might lose your position to go back to the original position to terminate that contract. Although, more likely than not, we will find that those specified defaults, as they're called, and they might generally repeat themselves as well.
It's quite an emotive issue, isn't it? I mean, you were talking about long-standing relationships here that often people don't want to kind of jeopardise. But in your experience, where this has happened between two parties, is there a way back? Do people kind of kiss and make up, or is that normally the end of it?
Absolutely. Because parties go into disputes, disputes do occur. The threshold for a dispute to occur is quite low. It's and there's quite good case law as to what defines a dispute or a difference between parties. I've often recognised and I've often seen that parties do have a disagreement, that they can get over these points and they do continue in a profitable relationship in the future. So it's always a possibility.
Looking at the issue of notice of termination, do people do this kind of because they're trying it on? I mean, is it almost, a threat, a vexatious threat? I mean, is that something that happens?
Well, the rules are very clear in that respect, and it's one largely point that we'd like to get across is that any notices, any conduct that is unbecoming or is not in accordance with the rules will only serve to go against the party as to their own conduct. And they must act. There's no duty per se under law to act in good faith per se. In terms of the NEC, does have provisions that the parties are to act in mutual cooperation. But the positive aspects on a party is not to use these threats to be vexatious. Mm. It's there because there has been a fundamental breach of the contract. The contract's providing a remedy in respect to have the parties continue on.
And could it be, though, that people are fearful when the other party starts talking like this, when they're making these vexatious sort of claims, if you like, that they will back down? I mean, is it important to stand your ground?
Well, certainly I think it is, Sean, particularly if that's a pattern of behaviour that reoccurs. And ultimately we would suggest that repeatedly threatening to terminate the contract may be an act of repudiation in of itself, because that is showing a lack of intention to be bound. One thing I did want just to add on to what Henry was saying about notices of termination, again, unsurprisingly, there are very important contractual terms that govern the way and manner and form of the notice. So something to watch out for. If you serve a notice ineffectively, it won't have the force intended, and of course that could be disastrous if you think you've terminated the contract and you pull your guys off site and you haven't properly served the notice and gone through the correct procedures. Again, you could be the one in repudiatory breach yourself.
But we have come across situations by which, actually identifying the process of when the trigger points are, and it's very clear that we have to identify what those. Has there been a default? Have instructions not been complied with? Have we abandoned the works? But it goes even back a long time before that. For example, with an employer, their due diligence on a company to actually realise, do they have the capacity to carry out these works in the first instance as well? And these are the type of points, because when these disputes arise, the situations might have occurred a long time ago, and the warning signs have always been there before this relationship actually occurs.
Well, that's the thing, isn't it, about preparation, both in terms of, preparing for all eventualities, preparing for the fallout. I mean, that is so crucial, I guess.
No, certainly. And I think just picking up what Henry said there, you'd be surprised the number of times that people act in shock because a company with minimal track experience, particularly potentially in the sort of work that they've just been engaged to do, suddenly found themselves incapable of conducting the relevant work. Now, yes, they'll be in breach because ultimately case law says if you're being paid to do a job and you've agreed to do it, well, it's your fault if you can't. But there's no point in hiring someone if they can't do the job. And so although that may lead to repudiation, the ultimate main contractor or the client still isn't going to get the job done.
You have sort of regular breakfast seminars where you look at a whole range of topics, and this is one of them. Is this a topic that you get a lot of questions asked about?
Absolutely. It's probably one of our most popular, that along with payment, along with extensions of time and third-party rights. What I would say is that the different circumstances, the different events that you hear about are varied, but they follow the same trends and they follow the same. Ultimately, when you break the issues down, there is always a commonality. And I think there's every opportunity for a party just to understand what those issues are, the commonality of the trends that occurs every so often, and start thinking about them as a business to avoid them.
Okay, well, I think we're going to have to leave it there. So once again, there's a lot to talk about, a lot to think about there. And if you'd like to find out more or get in touch with either Henry or Laughlan or a member of the Silver Shemmings Ash team, then go to the website silverllp.com. And don't forget those breakfast seminars too. Once again, thank you to our contributors, Henry Hathaway and Laughlan Steer, and thank you for listening.